How are you beautiful tubers today? I'm still trying to figure out what I'm doing here. Oh, that's not it. Where'd he go? Oh, yeah, I like that one. Anyway, so live coverage of Humphreys County, Tennessee appellate court. Not appellate court, criminal circuit court. And that's what we got. They're scheduled to start any second here. Hey, Sage, how you doing? Lady on Sky, what's up? Do you not know what's on the docket? The criminals, the accused. But you know what? Maybe I shouldn't wear orange when doing criminal court. I just realized that. But anyway, the accused are sitting in the back row. They just brought them in. Yeah, ours it's weird. Daylight. Like my skin starts to burn. I hiss at the sun. Oh, it's awful. Anyway. Hey Nickel, how you doing? I hope you are doing better. I hope to see more of you too. C-Swept, how are you? There's what's happening. Oh, there's you got a new avatar. Check this one out. Boom. A little that's a little freaky. Is that you? Is that a party? Did you just couldn't stand not showing off your red hair? Oh, guys. Anyway, so we're in Humphreys County, Tennessee. This is funny. Okay. Let me tell you guys a little Tennesseeism here. So this is the only court that's doing this. And it's not going to take long. And now Dixon County, Humphreys, all this stuff, they're outside of Nashville. They're about 30, 40 minutes. Used to be minutes, maybe miles outside Nashville. My door just closed. And it's a small community. I mean, look, this is the courtroom. I mean, it's like two folding desks, and I mean a couple of church pews. Now, what you think I can get away with wearing orange Tennessee? Yeah, probably. I mean, it is the Tennessee shirt. This is my sleep shirt. I just realized I hadn't. Sorry, we got Brown Dog's decided he wants out of the room. Anyway, it's I don't know. I've looked for more courtrooms like this, and I don't see one. So this judge, he's going to be. There'll be others. You'll watch, and they'll start getting jealous. They'll start hearing about this at like conferences, or some court clerk will come in and say, "Oh, hey, judge, have you seen what they're doing down there in Dixon County?" By the way, I don't like the wheels in this. I don't like anything right now. I don't like hearing. What is this out here? It burns. Oh, we still got Larry over here. He's got a sombrero. So, Nicola, you're in our prayers, and I'm sorry you're going through it. I think just know that you're not alone. So with that one, that's something that we're all kind of facing. So anyway, guys, how are y'all doing? So I've passed out last night. I was going to go on MG Laws, and I woke up and saw like his stream had ended like 10 minutes earlier at 2 a.m. I was like, holy cow. I made myself tired. I made myself tired just talking about it. 2:30, something like that. I was up. Then I couldn't go to sleep. It sucks so bad. So finally got to sleep and then woke up and saw this. I was like, oh, awesome. Awesome. Past 2 days have been tiring dealing with parents. The parent trap. It's the parent trap. Oh, hey, Miami Spice. How are you doing? You understand that. The parent trap. Oh man. I'm just you guys see me put on a hat and lean back. There's a good chance I fell asleep. All right, hang on a second. I gotta see what I'm doing wrong. All right, let's see here. Oh yeah. So it's funny. I just got a message came through. It's from our friend Valhalla, and it's from a message I sent him. And I sent it to him at 4 a.m. Crazy. We have different sleep styles here in Tennessee. It's all over the place. Um, what were they? But I have a sombrero. I have a baseball hat. That's a normal hat. That looks like I'm some sort of I don't know. I look weird in hats. I do have this here, but I look weird in it. I look weird in everything. Um, I don't know. I want this to get started. They came in. I was all excited. I was like, "Oh boy, look, we're gonna have some fun." And they're pounding away at the keyboards. You got one, two, three, four dudes back here. I mean, it's 10:36 Central Time, which is what time this is. They need to get going. Oh, hey, you know what? Maybe you guys can help me. Dude, this is a great group here to help me. So I'm looking to I want to get another flannel shirt, I think, but I don't know what color to get. Um, I want to show you guys, but I don't want to dox myself. How to do that? How do I turn that off? No, cool. Okay. All right, cool. We're still live streaming. All right, guys, check this out. Where'd I go? Oh, here I am. What do you guys think about that shirt? I know it's a traditional buffalo, red and black um, flannel, but I'm also where did the one go? No, is this one? No, where'd it go? That's a blue and black. So there was where'd the charcoal one go? And they didn't have navy either. Wait, hold on. What size are these? These are normal. Oh yeah, that one. So yeah, there it is. So it's that one. You got the red and black or the charcoal and black. What do you guys like? Sea Swept says the blue. Oh, it's a cheap Amazon shirt. I just need like uh I wear t-shirts most of the time. Hey to hell and back. How are you doing? Um Touch of class. How are you doing? Any with yellow. See, I don't think I'll look that good in yellow. All right, hold on here. Let's go back here. All right, they're still not going. Here you go. Where is that? There it is. So this is new. I haven't seen that, but blue, I don't know. Yeah, it's like that would not look good on me. That one looks like a Christmas present. I don't want to look like a Christmas present. Where is and now that's kind of cool because I've never seen a flannel that doesn't have a pattern. Whoops, wrong button again. So anyway, what do you guys think? Hey, Fofa. I say get one for you and one for Larry. Yeah, yeah. Larry probably does need something. You do like? See, I like that charcoal black. All right. Um, I'll show you. We have Dark Souls. That's scary. Yeah. Well, see, I want to get one and try it out. Here's the problem. So, like, I have to look at shirts, like what country they're made in, and because they don't fit me based on what country it is. It's the craziest thing. And like where I have a problem is like around my arms right here, like that part is like I don't know. It's and then of course like they had the whole bro shirt thing became popular where like your arms are real tight. I'm like, this sucks really bad. They don't fit. And then also I've never had anything across my back. I have a broad back and it sucks. Um, all right, let's see here. Where's the all right, so there's the charcoal, and of course, I mean that right there is a traditional flannel. Um, there's a guy ran for governor, Lamar Alexander, ran for governor of Tennessee. That was his um, calling card was the red and black flannel. It's weird. Uh, for some reason, I kind of like that's called black. I don't know why. I kind of like the solid, and that's a navy solid. I don't do well. I say I don't do a lot of blues. Actually, I do. A lot of my stuff is gray. See, I don't think that looks like something my grandpa would wear. That kind of looks like Christmas. That's a weird toffee. I'm not a toffee guy. There's blue. That kind of looks Charlie Brownish. I kind of like that. That's too electric. Boy, I'm picky. So I like that. Think I like this one. This one interests me. Okay, that's blue and orange. Is that a red, white, and blue? That may even be red, white, and blue as far as they know. Orange, burgundy, plaid. That's not bad. All right, I gotta get back over here. What are you guys saying? No to the yellow. No, no, no. What does the white rabbit think? Get whatever you want. I'm like, get whatever I want. If I got whatever I want, doesn't she know that men like to be controlled and told what to do? Holy cow. Yeah, that's the problem, Helen back. So like they have great return policies on this. My problem is that I don't make it back up to the post office. Hey Caitlin, how are you doing? Oh, that's cool. I said Caitlin and balloons popped up. Get them all. You guys are killing me. You guys are killing me. All right, let's see what's happening in Humphreys County. Up, just judge still isn't there. We got 3, 4, 5. There's 6 people on the docket. It looks like. What's he trying to do? Put off to lunch? Okay, so think about this, like on camera, because I mean I don't want to change clothes all the time, even though I do change clothes a lot. Hey, Rabbit, how you doing? Oh, that's not bad. Oh, it's a special deal. It's $19. Oh, and you guys see up here in my cart, I've got a the Dream laser where it makes like clouds. Yeah, that's 20% off. I'm not getting it, I just have it saved. But I do need a shirt because it's that time of year. Hey, Texas Jen. Texas Jen, I need a shirt and nobody's helping me. C swept. So you like that one better than that one, right? What about this one? Why am I so onto this one? I probably wouldn't like it. I may like that one the best. Does that look too that looks like a kilt, doesn't it? A lot of the chat were saying charcoal, Sage. Thank you, Sage. That's the charcoal. This one or the solid black one? Which does that look black to you? That looks charcoal color. All right, so you like this one, Texas Jen? Oh, the bigger print shows up better. Mm. Waifu, how are you doing? You like this one? All right. We're gonna see how that works. We're gonna save that one for later. There you go. I'm adding it to cart. You guys got me. So let's see here. Look at this thing. So it's 30% off. Yeah. Because see, Miami Spice said she didn't like the lasers. So I was like, well, look at this. She could have dreams. Oh, look at that. Oh, princess dreams. See? That'd be Miami Spice could pretend that she's like down here looking in the background, has all these like cool little clouds. That looks like they're trying to hypnotize children. That's cool. Not really. That looks like they're stuck in a monster stomach. What is going on here? What's darling? Is that Tia Carrera? No, wait, that's Tia Tequila. Yeah, gaming with nobody there. Waifu is are we supposed to do our thing tonight? Is that still a thing for you? And so we're still waiting. No, I have not seen her lately, but I have a feeling it's not good. Texas Jen. So that the Dream Machine thingy, it's $18, but it's 30% off. So it's like 5 something off. So it's like $13. I'm thinking that's gonna have to replace the laser beams because they don't work that well anymore. Oh, don't say that to me. Oh, well, now we know I'm gonna be getting a Dream Machine before I get a shirt. Okay, I have one. I'm embarrassed to show you guys this. What link are you looking for, Miami Spice? Tequila? Where'd it go? Where's my little fast forward? Oh, there it is. Copy link. And look at this. I love doing shopping for y'all. There it is. Oh, wait, hold on here. I messed that. I did mess that. No, we're not bailing. There's no bailing here. You're bailing me out. Trouble. Oh, wait, what'd she say? Waifu says, I've been gravitating towards the black, dark gray, and tan. Send you some links. Awesome. Awesome. See, so it's a link to Expert's Dream Machine. Oh my gosh, you guys are crazy. Hey, Nandor, how are you doing? Still have not gone back into the show. Okay, here's what happened. This is what I was going to tell you. So when I was at the dentist, I had to find something to listen to, and I put in what's the name of that show with Nandor, Nandor, whatever it is. I like it, but here's what I've learned: when you're like listening to stuff like that, it helps if you've already seen it. Because I've been like now like 10 episodes in, and I don't know a single thing that's going on. That's my problem. So I got to start all over. Oh, well. Hey, Geo Twins, how are you doing? Oh, the Nandor or this? Oh, wait, hold on. We got talking. No, we don't. Why are we talking? Oh, here he is. Let's see what's happening. Hey, Jamie, how you doing? Thank you, Jamie.
Mr. Hooper, perhaps you just want to take them in the order that you like.
Yeah, David Wolf. Bowers. This guy, he's going to be the most popular dude in Tennessee.
Matthew Lee Bowers on page 1. Probation violation.
Oh, probation violation.
Your Honor, this is a drug court entry plea.
Drug court.
The only thing that I do not have, and I was just telling Miss Lemons, is his jail credits. I got said it was the wrong person. So, Mr. Bowers.
So great seeing Texas Jim back in the chat. Yeah, don't be good, Sage. Just be good at it.
If it was for a hearing, I would know.
What is this all about? I don't see Jamie as a kitten.
All right. Been indicated that Mr. Bowers is going to admit his violation of probation. He reinstated and transferred to community corrections. A condition of his community corrections will be that he enter and complete drug court and remain in jail until he's picked up by a drug court representative. Any pre-2021 community corrections guidelines, drug screens, entire sentence, and zero tolerance. All right, Mr. Bowers, raise your right hand. Let's place you on the road.
You solemnly swear or affirm that the testimony I give in this case shall be the truth.
Guys,
the
this
whole
is
truth,
probably
and nothing but the
99% of
truth,
all
God.
criminal cases are
State your
just
full name
like
for the
this.
record.
This is really, I find
Bowers,
this stuff
you're here today on a
fascinating.
charge of violation of probation, actually going to be transferring you to community corrections, but you've heard what I've said the agreement is. But do you understand you have a right to plead not guilty and to have a hearing in this court where the state would be required to prove to the legal standard that you had violated your probation?
Yes, sir.
You understand that you would have the right to have a lawyer and have one appointed, as I've done with the public defender.
Yes, sir.
You understand if you went to that hearing, you would if we had that hearing and I found you guilty, you could appeal whatever I did in your case to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal.
Yes, sir.
You understand that by entering this plea of guilty, you're
By
waiving
Miami.
the right to hearing and to an appeal. All I'm going to do is approve what you have worked out with the state, and that is that you're going to be transferred to community corrections. You understand that? All right. Do you wish to plead guilty and waive your right to a hearing and to an appeal?
Yes, sir.
All right, then I find you guilty, or that you be revoked to serve your sentence, but on time served and by agreement with the state, you will be reinstated and transferred to community corrections for the completion of your sentence. You are now going into the recovery court entry, or rather recovery court or drug court as we call it. And on the order that I'm required to sign, it says that on this date that you came into open court accompanied by your attorney, and on the record, your plea of guilty was already accepted. And you wanted to enter the drug court program. And it states that in open court, it was explained to you that recovery court does not operate in the same manner as traditional court of law. Recovery court is primarily a treatment protocol using the enforcement powers of the court as a means of ensuring
like a
adherence
probate court.
to a therapeutic course of addiction treatment. You must understand and agree that in order to be successful, the court must have the flexibility to operate in ways not usually considered commensurate with the constitutional protections afforded the traditional criminal defendant. Recovery courts closely supervise, monitor, test, and treat substance abusers and are based on partnerships among the courts, law enforcement, corrections, and social welfare agencies. They offer a therapeutic setting involving a regimen of graduated sanctions and rewards, substance abuse treatment, close court monitoring and supervision of progress, education, or vocation counseling as appropriate, and other requirements. Therapeutic effectiveness of these programs relies on the recovery court's ability to immediately reward or punish participants for their behavior. Excuse me. After this explanation and in agreement with the foregoing, you must in open court waive the following rights to enter the recovery court. 1, the right to be sentenced within 30 days. 2, the right to immediate execution of sentence. 3, the right to be represented by counsel at recovery court proceeding. 4, the right to confront witnesses against you in recovery court proceeding. 5, the right to have your medical history kept confidential from the recovery court team. 6, the right to have written notice of any alleged violation of recovery court rules and the evidence against you. 7, the right to have an opportunity to present witnesses and evidence in your behalf and an opportunity to have a hearing in recovery court on the alleged violation. 8, the right to confront and cross-examine the witnesses against you concerning any alleged violation of recovery court rules. You must further waive such rights as are necessary for the recovery court to exercise the following powers: to search your person, residence, vehicle, and effects
recovery
at such
court is
times
more
and
like
places as are deemed
going
proper
through
by the recovery
probation
court team
or
without the
parole.
necessity of a warrant nor probable cause therefore.
Probation.
To require
Sorry.
you to submit to random drug tests at such time and place as
I
as
guess for
determined by the
referral too.
recovery court team. The recovery court team may consider your analysis results without any testimony or evidence concerning how the test was performed, scientific basis for the testing procedure, the chain of custody, and the accuracy of the testing results. To sentence you to jail for a period of time determined by the recovery court team without the necessity of notice or a sentencing hearing. Any such period of incarceration will be credited against the sentence which you are presently serving in recovery court. To require you to reside at a designated location, including but not limited to a sober living facility operated by the recovery court, and to obey the rules of the sober living facility. To undergo such additional treatment as determined by the recovery court team, and to enforce the rules of the recovery court as set forth in the current edition of the recovery court rules handbook. Furthermore, you must agree that if you are terminated from the recovery court, that you will not be guaranteed that you will not receive a greater sentence than the original plea bargain. You would not receive any credit against your sentence for time spent in the recovery court except for periods of incarceration. You must further agree that if you leave the program for any reason, any and all rights that you have waived to enter the program are restored to you, and the waiver of rights to enter the recovery court becomes null and void after the date of the termination from the program. The court may impose intermediate sanctions for noncompliance with the requirements of the program, which may include incarceration in the county jail for a specified period of time. Such periods of time will be credited against your sentence. If you are terminated from the program, you will be required to serve the sentence ordered by the sentencing court or be afforded a hearing on a violation of probation petition as determined by the appropriate judgment docket. If you graduate from the recovery court program, you will receive full credit for the time spent in the recovery court program against your sentence or period of probation. You acknowledge and agree that upon completion of and graduation from the 23rd Judicial District Recovery Court Program, the participants' your criminal cases will be referred to continuing supervision through the state probation, and that compliance with aftercare provisions mandated by the 23rd Judicial District Recovery Court Program will constitute conditions of such supervised probation pending further orders of the court. You must understand that the recovery court judge has the final determination of who may enter the recovery court program and whether you, as a participant, will be terminated from the program for violation of the rules of recovery court. I need you to state in open court that you have discussed these matters with your attorney and that you fully understand this waiver and you freely voluntarily agree to the terms contained therein. Do you so state?
Yes, Your Honor.
All right. And it's therefore found by this court that you will be a participant in the 23rd Judicial District Recovery Court Program.
Thank you, sir.
So what Sage is saying is correct. I mean, I feel the same way. Is that drug court allows, it's like recovery or like an AA type thing, but it's done by the government, by the state, and you don't get, because jails are not a lot of times people go to jail and they come out worse. Jails are kind of like a training ground for some people. I see swap. All right, now C swap's
All right,
gone.
I've been handed another plea agreement for Mr. Moore.
I'm
I
teasing.
suppose I could have had them both up here at the same time. Mr. Moore has been indicated that you want to enter a plea of guilty to your violation of community corrections and
Your Honor,
revoke.
Roger, we have a third one if you want to do that one as well.
Each one of them has to acknowledge it on the record individually, so let's just do them individually. I love the sound of my own voice.
I love this
Yes,
guy.
indicated you
He's so
willing to
dry.
admit and be revoked and reinstated community corrections, but are resentenced for 10 years and under pre-2021 community corrections guidelines. It will be additionally required as a requirement of a condition of your community corrections that you complete drug court or recovery court and undergo regular drug screens for your entire sentence, zero tolerance, and you must stay in jail until you're picked up by the drug court. So, Mr. Moore, raise your right hand. Let's place you on the road.
You solemnly swear or affirm that the testimony shall not give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God.
State your full
I
name for
love
the
that
record.
court clerk. That sounds like every
More,
court
you've
clerk in
heard me state
Tennessee.
what the agreement is, but you understand you have a right to plead not guilty and to have a hearing in this court where the state would be required to prove to the legal standard that you have violated your
Yeah,
probation.
I do too.
You understand if we had that hearing, you would have the right to have a lawyer and have one appointed, as I've done with the public defender.
Yes, sir.
You understand if we had that hearing and I found you guilty, you could appeal whatever I did in your case to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal.
Yes, sir.
You understand that by pleading guilty, you're waiving or giving up your right
Yeah,
to
it
an
is.
attorney, to a hearing and to an appeal. All I'm going to do is approve what your lawyer has worked out for you.
Yes, sir.
You
That's the
understand
court
that's going
clerk.
to mean that you're being resentenced to a 10-year sentence.
Yes,
And
sir.
that means if you're going to be on community corrections for 10 years, it's a long time. How old are you?
31.
You'll be 41 before you're finished with your probation. You understand that? And that's if you are successful. So as a requirement of that, you're going to have to complete successfully the drug court program. You understand that?
Yes, sir.
Do you understand everything I've explained to you?
Yes, sir.
Do you want to plead guilty to this charge according to this agreement and give up your right to a hearing?
Yes, sir.
Then I find you guilty of violating your probation in order that you be revoked. That on time served and by agreement with the state, you'll be reinstated to community corrections and resentenced to 10 years. And this will be served under pre-2021 community corrections guidelines, and completion of drug court will be a condition of community corrections, including regular drug screens for your entire sentence with a zero tolerance. And you
10
have to
years
stay
of
in
drug
jail
screen-
until
drug
such time as
screens.
you are picked up by a drug court representative. Now, you may ask, why is he going to read me the same thing he read this other individual? Because I'm going to have you acknowledge under oath that you have had it read to you because the order says that. And what we have sometimes are people who come back that's been put in drug court and they say, well, I didn't fully understand what I was giving up in the rights. I want a hearing, I want this or that. And I want you to understand what you're giving up when you enter into the drug court program. You understand that?
Yes, sir.
Right. So that's why I'm doing it.
They have
I
to
love
pay
hear the
for
sound
their
of my own
drug
voice,
testing,
because I want
too.
to make sure you have individually have this explained to you.
I understand.
All right. In open court, it was explained to you that recovery court does not operate in the same manner as a traditional court of law. Recovery court is primarily a treatment protocol using the enforcement powers of the court as a means of ensuring adherence to a therapeutic course of your addiction treatment. You must understand and agree that in order to be successful, the court must have flexibility to operate in ways not usually considered commensurate with the constitutional protections afforded the traditional criminal defendant. Recovery courts closely supervise, monitor, test, and treat substance abusers and are based on partnerships among the courts, law enforcement, corrections, and social welfare agencies. They offer a therapeutic setting involving a regimen of graduated sanctions and rewards, substance abuse treatment, close court monitoring and supervision of progress, educational or vocational counseling as appropriate, and other requirements. The therapeutic effectiveness of these programs relies on recovery court's ability to immediately reward or punish participants for their behavior. After this explanation, and in agreement with the foregoing, you in open court must waive the following rights to enter the recovery court. The right to be sentenced within 30 days, the right to immediate execution of sentence, the right to be represented by counsel at recovery court proceedings, the right to confront witnesses against you in recovery court proceedings, the right to have your medical history kept confidential from the recovery court team, the right to have written notice of any alleged violation of recovery court rules and the evidence against you, the right to have an opportunity to present witnesses and evidence on your behalf, and an opportunity to have a hearing in recovery court on the alleged violation. The right to confront and cross-examine the witnesses against you concerning any alleged violation of recovery court rules. You must further waive such rights as are necessary for the recovery court to exercise the following power: to search your person, residence, and vehicle and effects at such times and places as are deemed proper by the recovery court team without the necessity of a warrant nor probable cause thereof. To require you to submit to a random drug test at such time and place as is determined by the recovery court team. The recovery court team may consider your analysis results without any testimony or evidence concerning how the test was performed, the scientific basis for the testing procedure, the chain of custody, and the accuracy of the testing results. To sentence you to jail for a period of time determined by the recovery court team without the necessity of notice or a sentencing hearing. Any such period of incarceration will be credited against your sentence, which you're presently serving in recovery court. To require you to reside at a designated location, including but not limited to sober living facility operated by a recovery court and to obey the rules of the sober living facility. To undergo such additional treatment as determined by the recovery court team. To enforce the rules of the recovery court as set forth in the current edition of the Recovery Court Rules Handbook. Furthermore, you must agree that if you are terminated from the recovery court, that you will not be guaranteed that you will not receive a greater sentence than the original plea bargain. You would not receive any credit against your sentence for time spent in the recovery court except for periods of incarceration. You must further agree that if you leave the program for any reason, any and all rights that you have waived to enter the program are restored to you, and the waiver of these rights to enter the recovery court becomes null and void after the date of the termination from the program. You understand that the court may impose intermediate sanctions for non-compliance with the requirements of the program, which may include incarceration in the county jail for a specified period of time. Such periods of time will be credited against your sentence. If you are terminated from the program, you will be required to serve the sentence ordered by the sentencing court or be afforded a hearing on a violation of probation petition as determined by the appropriate judgment document. If you graduate from the recovery court program, you will receive full credit for the time spent in the recovery court program against your sentence or period of probation. You acknowledge and agree that upon completion of and graduation from the 23rd Judicial District Recovery Court program, your criminal cases will be referred to continuing supervision through state probation, and that compliance with the aftercare provisions mandated by the 23rd Judicial District Recovery Court program will constitute conditions of such supervised probation pending further orders of the court. You must understand that the recovery court judge has the final determination of who may enter the recovery court program and whether you as a participant will be terminated from the program for a violation of the rules of recovery court. I need you to state in open court that you have discussed these matters with your attorney and that you understand fully
The attorneys are there on his
freely and voluntarily
iPhone.
agree to the terms contained therein. Do you so state?
I do.
And I find that you will be a participant in the drug court program. Good luck to you.
Yes, sir.
I know you got a guy with maroon. Oh no, he's leaving. Nope, here he comes. So what's maroon mean?
Oh, thank you.
And I may not be saying it right.
We'll take a break from drug court for a minute, Judge.
We'll take a break from drug court for a few minutes.
All right, Mr. Roy.
This guy's Dan
indicated you're
Fielding, by the way.
going to plead no contest to a charge of manufacturing, delivery, sale, or possession with intent of a controlled substance and receive a sentence of 8 years in Tennessee Department of Corrections, suspended to probation on time served, a $2,000 fine, and cost, random monthly drug screens for the entire sentence, and a zero tolerance for a failed drug screen violation. Right. Mr. Roy, raise your right hand. Let's place you under oath.
You solemnly swear or affirm that the testimony I give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God. Thank you.
We're going to record everything we're saying here today, so your answers must be loud enough for us to be able to pick it up. State your full name for the record.
Timothy Wayne Roy.
Mr. Roy, you're here today charged with a possession of with intent to sell methamphetamine, but have you seen or been shown a copy of those charges, and you and Mr. Hooper had a chance to talk them over, discuss with him the range of punishment you're facing as well as any possible offenses you might have?
Yes.
You feel like you fully understand what you're charged with?
Yes.
Now, here's the problem. If there's any hesitation, you are set for trial pretty quickly, I think Friday.
Yes.
So if you don't want to take this agreement for probation, then we'll let you go to trial. It doesn't matter to me whether you do it, but do you understand that's what you're charged with and this is what the agreement is?
Yes,
Right. Do you understand you have a right to plead not guilty and to have a speedy and public trial by jury on Friday?
yes,
You understand you would have the right to have a lawyer and to have one appointed as we've done with a public defender?
yes,
You understand if you went to trial, you'd be presumed to be innocent until such time, if ever the state proved your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous for you to be able to be convicted.
Yes.
Do you understand that if you went to trial, you and your lawyer could confront and cross-examine every witness the state called to testify, and you could bring in your own witnesses by the use of a subpoena?
Yes.
You understand that you would be presumed to be innocent. You would not have to testify or prove anything, and there would be no inference of guilt arising because you did not testify at your own trial.
Yes.
Do you understand that if you went to trial and you were found guilty, you could appeal the conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal?
Yes.
You understand that by pleading no contest, you're giving up your right to a trial and to an appeal. All you're doing is saying, I know what the facts are. I'm not going to admit I did anything, but I'm not going to deny it either. And the state's then going to tell me what their evidence would be, and I will find you guilty. Do you understand that waives your right to a trial and to an appeal? You understand that's going to result in a conviction, and that conviction will be on your record in the future to make more severe the punishment you'll receive if you're ever again convicted of a crime. You understand
just
all the rights
realized
that
I
I'm
went
explaining
to
to you.
college
You want
with
to
a
plead
girl
no
from
contest and give
Humphreys
up your right
County.
to a trial and to an appeal.
Yes.
Is your decision to plead no contest today voluntary? Is anybody forcing you to do this? You understand I have to have facts
It's Waverly,
presented to me that
Tennessee,
will allow me
New
to find you
Johnsonville,
guilty.
Tennessee.
So I need you to listen as the state tells me what their evidence would be if this case went to trial.
Right, this going trial, the state was expected to show that on or about July the 12th, 2022, Mr. Roy agreed to sell 8 balls of methamphetamine to a confidential informant who is working with the Humphreys County Sheriff's Office. Undercover detectives monitored the sale and watched Mr. Roy deliver the methamphetamine to the parking lot and fast fuel to the confidential informant. The methamphetamine weighed out to be 1.29 grams PPA.
Fine, I'm not asking that you agree with those terms, but you understand that's what the state's evidence would be if you went to trial.
Yes.
You still wish to plead no contest.
Yes.
Are you satisfied with your attorney's services?
Yes.
I feel like Mr. Hooper's done a good job of representing.
According to
your client. Hooper, you know of
tweaker.org,
any reason you should not
an
name
8
this
ball
person?
of meth is worth
Anything
between
further from the
$120 and
state?
$160.
And Timothy Roygan, docket number 14721, upon your plea of no contest to the single count of
How many
that
people go to
indictment, Class B
tweaker.org
felony,
to
I
give
find
you
you guilty,
updates on
sentence you to
street
8
drug
years in the
prices?
Tennessee Department of Corrections.
I do.
That will be suspended to
for you guys. I
probation on
love y'all.
time served with a $2,000 fine at cost. You are, as a condition of your probation, required to undergo random monthly drug screens for the entire length of your sentence. Any failed drug screen will be a zero tolerance violation, resulting in a violation of probation. Good luck to you.
Yeah, and it's Tennessee's one of the worst states too for drugs. It's so weird.
We're doing the men first, in case I need to take them back to jail.
This is the what?
Bond, he thought a pro se motion for bond that I
Okay.
started earlier, and General wanted.
He forgot to comb his hair today. He didn't know he had
General, have
court.
you had an opportunity to investigate it at all?
Well, Judge, I'm taking Mr. Hooper's word that he was in court. I trust Mr. Hooper, but I do know that Judge Lockhart actually wrote his bond. But before a bond was either set or reinstated, I wanted the court to realize that he has received new charges since he's been in jail.
New charges since he's been in
But also,
jail.
those are pending now, Judge. He does have bond set on those, is my understanding. So that's why we're asking for the original one to also have the bond set.
You want to offer any proof on this?
So. No, I'm just what I told the court. I don't have any proof other than what I've, as a officer of the court, and telling the court, I know where he was that day. That would be the only proof reinstated.
I do not like this.
What was
Public
the new
defender.
charge?
I can't.
It's always trying to walk
I
away.
can't. It's either vandalism or assault. I don't know which one.
I can't remember.
Vandalism and assault are two very, very different charges.
Both.
Hey, infamous truth teller, how are you doing?
Assault on a first responder, Judge, and a vandalism.
And that he's been granted bond on?
There is a bond. on-
There's a bond set.
And we have not filed a motion to revoke this bond because it's already revoked.
You're only half an hour or so away from
Is
that
your
court. Yeah,
intention?
It's kind of bad.
If you set a bond, I may well file a motion.
I hate
Well-
to hear that too.
We have a motion to be relieved of the surety bond, which means that his bullseye bond, bail bonds, has filed a motion back in July to be relieved of his bond because he failed to appear in court.
Humphreys had really bad floods a few years ago, didn't they?
By statute, the bonding company is
Flash
entitled to
flooding.
relief from that bond because of the fact he failed to appear and he's subsequently been arrested. He doesn't have provision for the fact that he was justifiably being held in another location.
Yes, sir.
So his bond was $7,000 immediately originally on this first case. Seems like a low bond, $7,000. Mhm.
I think that a magistrate must have set that on the Virginia Sessions.
$5,000 on the first one, 1,000 on each of the two misdemeanors. Apparently, is how it was around.
Infamous Judge Wolf here does he's a circuit judge. In his circuit, they do a lot of criminal. Of course, they do probate, civil, all that stuff. And he is he's the only one I found that has a regular docket in Tennessee
And
of
these new charges
the
are
day-to-day
found over
court
the
hearings.
section
And so people just there's so many court streaming, so many streamers out there, so many highly qualified people. But like, you know, I'm in Tennessee. I understand it. I'm going to cover this
So
stuff.
there's a bond set.
And this is what 90% of your court
Currently,
stuff
it
is.
appears to
So
me that bond has been revoked and never been reinstated by the
It's just an
court. So
inside
he
look
doesn't
of
have a
the
bond presently.
everyday court system.
And based upon that fact, there was a bond set in the lower court of $7,000. That is the bond that was revoked.
There's that one that picked up
Due to
that
these new
like that
charges
mobile
before,
home. The woman was on the front
bond was to be
porch.
set, I would have to have a hearing and set
She
a
went down the
bond amount
river.
that I thought was appropriate. But currently, he doesn't have a bond.
I can't remember.
Therefore, in light of the fact that the state's indications are he has new cases coming out of the grand jury, I declined to set a bond for him or to reinstate his original bond, even though there may have been a justifiable situation. If that was the case, then it certainly has changed since he was in jail in Montgomery County and missed his court date. Because of the fact that the statute allows the court as a matter of law to revoke a bond for someone who commits a new offense or is charged with a new offense while on bond for the original charge. So,
Yes, sir.
so it seems to me to be an academic exercise for us to set another bond, then only have the state turn around and file a motion to revoke that bond, which would be likely granted by the court. So at this point, I'm not reinstating his original bond, nor am I setting a new bond amount at the present time. So
Yes, sir.
Just for the record, Mr. Buckholz filed a pro se motion for speedy trial. He is set for trial on December the 8th. I don't think we can get much speedier than that.
I will try him on Friday.
Not sure I would be prepared when I was planning that one in December.
And that would only be if our vehicular homicide finishes by that time. But the let's see what the new bond is. How much is the new bond hold for a hearing?
Yes, sir.
All right, let's see what happens with those new charges, and then you can revisit the bond issue.
Yes, sir. Thank you. Well,
Well, they put her in with general population, right?
give me 1 second. Ron.
Who's
Come on in, bud.
Mr. Phelps?
Brown dog decided he wanted to say hi. Hey. Hey, Bubba. We make some videos of you today.
to go into other details.
Brown Dog goes
Oh.
Monday
This,
for his surgery on his other ACL.
Phelps, I've been handed two documents. One is the violation of probation or community corrections, rather. It indicates that you are going to admit your violation and be revoked and reinstated to community corrections, but a condition will be that you complete drug court, that you will be supervised under pre-July 2021 guidelines of the community corrections. You'll have drug screens for your entire sentence with a zero tolerance drug screen for your entire sentence. And in the new case that you have, introduction of contraband into a penal facility, you would receive a sentence on your plea of guilty to 6 years Tennessee Department of Corrections, suspended community corrections consecutive to your current community corrections case. And that would be a condition of your community corrections that you complete drug court supervision under pre-2021 guidelines, drug screens for the entire sentence with zero tolerance for your entire sentence. Right. Just raise your right hand and have you placed under oath.
You solemnly swear or affirm that the testimony I give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God.
State your full name for the record.
Victoria Page Phelps.
Ms. Phelps, you are here today on two different types of cases, so I'm going to have to deal with them separately. On your violation of community corrections, do you understand you have a right to plead not guilty and to have a hearing in this court where the state would be required to prove to the legal standard that you have violated your community corrections?
Yes, sir.
You understand you would have the right to have a lawyer and have one appointed for you if necessary?
Yes, sir.
You understand if we had that hearing and I found you guilty, you could appeal whatever I did in your case to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal.
Yes, sir.
You understand that if you are pleading no contest or guilty, I guess it is, guilty to the violation of community correction, you're waiving your right to that hearing without appeal. All I'm going to do is revoke you, but reinstate you on time served by this agreement to community corrections under those new conditions.
Yes, sir.
Do you understand everything I've explained to you about that charge?
I do.
Do you want to plead guilty to the charge of violation of the community correction?
I do.
Then I find you guilty or that you be revoked, but reinstated on time served to community corrections. And a new condition will be you complete drug court and that your supervision will be under pre-July 2021 guidelines. You are to undergo drug screens for your entire sentence with a zero tolerance for drug screens, positive drug screens for your entire sentence. Now, the new charge of introduction of contraband into a penal facility, a Class C felony, do you understand what you're charged with? And have you and Mr. Hooper had a chance to talk over that case and discuss the range of punishment you're facing as well as any possible defenses you might have?
Yes, sir.
Well, it's indicated you want to enter a plea of guilty to that charge. Do you know that you can plead not guilty and have a speedy and public trial by jury?
I do.
You understand if you went to trial, you would have the right to have a lawyer and to have one appointed as we've done with the public defender.
Yes, sir.
You understand at trial, you would be presumed to be innocent until such time, if ever the state proves your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you could be convicted of anything. You understand that if you went
Yes.
to trial,
I
you
do
and
know
your
the
lawyer
line
could
between the
confront
lakes.
and cross-examine every witness the state called to testify against you, and you can bring in your own witnesses by the use of a subpoena.
Yes, sir.
Do you understand you would be presumed to be innocent? You would not have to testify or prove anything at trial, and no inference of guilt would arise because you did not testify at your own trial.
Yes, sir.
You understand that if you went to trial and you were found guilty of a crime and sentenced for that crime, you could appeal the conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal.
Yes, sir.
Do you understand that by pleading guilty, you're waiving your right to that trial and to that appeal? All I'm going to do is approve what your lawyer has worked out.
I do.
That's going to result in a new conviction that will be on your record, a felony, that will be on your record in the future to make more severe the punishment you receive if you're ever again convicted of a crime.
Yes, sir.
Do you understand everything I've explained to you?
I do.
Do you want to plead guilty and give up your right to a trial and to an appeal according to this agreement?
I do.
Do you understand if you plead guilty, the court of the state could ask you questions about this offense, and if you answer those questions under oath on the record and in the presence of your lawyer, your answers could later be used against you in a prosecution for perjury if we determine that you are lying under oath.
Yes, sir.
Is your decision to plead guilty today voluntary?
It is.
Anybody forcing you to do this?
No, sir.
You understand I have to have facts presented to me to show that you are in fact guilty of this charge.
I do.
And are you in fact guilty of this possession of introduction of contraband into a penal facility? What happened?
I brought drugs to the facility and 3 people overdosed. They were revived and brought back. And it wouldn't have happened unless.
He wants you to say a little bit, but not too much.
Well, it was my fault. It was my fault, for sure. I take full responsibility.
Understand. Well,
Holy
at least
cow.
that's a step in the right direction.
Holy moly. So she brought,
Are you satisfied with your attorney's services?
what was the facility
You
she
feel like
brought
Mr. Hooper's
drugs
done a good
to?
job of representing you.
I do.
Mr. Hooper, do you have any reason she should not enter this plea?
I do not.
Now that you've stopped her from talking further.
Well, the less is better, Judge.
Anything further from the state? Then Victoria Phelps in docket number 14834, upon your plea of guilty to introduction of contraband into a penal facility, I find you guilty, sentence you to 6 years. Tennessee Department of Corrections, that will be suspended to community corrections as consecutive to your prior violation of community corrections. Same conditions
How
will
many people did
apply
she say
in this.
overdosed?
You must complete the drug court, and your supervision will be under pre-2021 guidelines. And the drug screens for the entire sentence, which will be 0 tolerance for your entire sentence. Right. Now you're
3
going
people?
into
Yeah. Hey, Kelly Dime.
the drug court program. So
Didn't you love those? She goes,
we'll go
well,
over those rights
it was
and
my
make sure that
fault.
you understand the
I
rights
take
that you're giving up.
responsibility.
People have certain rights constitutionally. That they are guaranteed certain rights: the right to confront their accuser, the right to have an attorney, and so forth. And you're going to hear that you're waiving all of those type of constitutional rights to go into this program. No one's forcing you to do it. If you do it, you're waiving it voluntarily, but they will be waived. You understand that? Right. In open court, it was explained to you that the recovery court does not operate in the same manner as a traditional court of law. Maybe I should read this with some emphasis, like it was a dramatic reading. Recovery court is primarily a treatment protocol using the enforcement powers of the court as a means of ensuring adherence to a therapeutic course of addiction treatment. You must understand and agree that in order to be successful, the court must have the flexibility to operate in ways not usually considered commensurate with the constitutional protections afforded a traditional criminal defendant. Recovery courts closely supervise, monitor, test, and treat substance abusers and are based on partnerships among the courts, law enforcement, corrections, and social welfare agencies. They offer a therapeutic setting involving a regimen of
Right,
graduated
Callie?
sanctions and
I mean, it's
rewards,
just, she like,
substance
she kind
abuse
of giggled
treatment,
then. She's like,
close court
well,
monitoring and supervision of progress,
I did it.
educational or vocational counseling as appropriate or other requirements. The therapeutic effectiveness of these programs relies on the recovery court's ability to immediately reward or punish participants for their behavior. After this explanation and in agreement with the foregoing, you in open court must waive the following rights to enter the recovery court: the right to be sentenced within 30 days, the right to immediate execution of sentence, the right to be represented by counsel at recovery court proceedings, the right to confront witnesses against you in recovery court proceedings, the right to have your medical history kept confidential from the recovery court team, the right to have written notice of any alleged violation of recovery court rules and the evidence against you, the right to have an opportunity to present witnesses and evidence in your behalf, and an opportunity to have a hearing in recovery court on the alleged violation, the right to confront and cross-examine the witnesses against you
Yeah,
concerning
if
any alleged
somebody had
violation
died,
of
it'd be a
recovery
murder
court
trial,
rules.
but it's still, it's,
You must
fact that,
further
I mean,
waive
you can-
such rights as
you
are
die from
necessary for the
overdoses,
recovery
right?
court to exercise the following powers: to
and she's just
search your
nonchalant
person,
about it.
residence, vehicle, and effects at such times and places as are deemed proper by the recovery court team,
It's like those
without
videos
the
you see
necessity
of
of a warrant,
the
nor
people get
probable
arrested for
cause therefor.
DUI and
To
they like
require you
hit
to
somebody
submit
and
to
they're
a
like,
random drug
when
test
do I
at
get
such
out of
time and
here?
place as determined by the recovery court team. The recovery court team may consider your analysis results without any testimony or evidence concerning how that test was performed, the scientific basis for the testing procedure, the chain of custody, or the accuracy of the testing results. To sentence you to jail for a period of time determined by the recovery court team without the necessity of a notice or a sentencing hearing. Any such period of incarceration will be credited against your sentence that you are presently serving in recovery court. To require you to reside at a designated location, including but not limited to a sober living facility operated by the recovery court, and to obey the rules of the sober living facility,
False alarm.
and to undergo such additional treatment as determined by the recovery court team, to enforce the rules of the recovery court as set out in the current edition of
Where'd
the
that go?
recovery court rules handbook. Furthermore, you must agree that if you are
Yeah, I know you're
terminated
making
from
fun
the
of me.
recovery court, that you will not be guaranteed that you will not receive a greater sentence than
It's
the
Tennessee at
original plea
least.
bargain. You would not receive any credit against your sentence for the time spent in the recovery court except
This
for the
chick took
periods of
drugs into a
incarceration.
rehab
You
facility
must
and people
further agree that
overdosed.
if you leave the program for any reason, any and all rights that you have waived to enter the program are restored
like
to
that.
you. And the waiver of rights to enter the recovery court becomes null and void after the date of termination from the program. The court may impose intermediate sanctions for noncompliance with the requirement of the program, which may include incarceration in the county jail for a specified period of time. Such periods of time will be credited against your sentence. If you are terminated from the program, you will be required to serve the sentence ordered by the
You have
sentencing
to.
court or be afforded a hearing on a violation of probation petition as determined by the appropriate judgment document. If you graduate from the recovery court program, you will receive full credit for the time spent in the recovery court program against your sentence or period of probation. You must acknowledge and agree that upon completion of and graduation from the 23rd Judicial District Recovery Court Program, your criminal cases will be referred to continuing supervision through the state's probation, and that compliance with aftercare provisions mandated by the 23rd Judicial District Recovery Court Program will constitute conditions of the supervised probation.
Yeah, he's a really
pending
nice
further
judge,
court.
Callie.
You must also understand that the recovery court judge has the final determination of who may enter the recovery court program and whether the defendant, you as a participant, will be terminated from the program for a violation of the rules of recovery court. I need you to, in open court, state that you have discussed these matters with your attorney and state that you understand fully this waiver and freely and voluntarily agree to the terms contained therein. Do you so state?
I have.
All right. And I will approve you as a participant in the drug court program, and I hope you have good luck.
Thank you.
Thank you, Judge.
And I hope you have good luck.
Last one I have, Your Honor, at this time is Ms. Turner. That will be.
Come about with that. Okay, fine. Don't come in here.
I sent her the Zoom link.
Well, I have 5 people in the, hold on a second. You said, who am I looking for?
Haley Northcutt, Your Honor.
All right, we have her.
Sorry, Judge.
Who?
Haley Northcutt,
Okay. We were on Missy Turner.
Northcott, I'm sorry.
Northcott, apparently it's a witness.
Oh, okay.
No, this is just court today. This is court in Humphreys County, Tennessee. The criminal
Morning, are you Haley Northcott?
criminal court.
I am.
This is what happens every
Would you
day of
start
the
your video,
week,
please,
all
if
across the
you have
country.
ability. All right, thank you.
Oh,
Sorry to keep you waiting, but we are ready for this case. State ready. This defendant's name is who?
Mr. Turner, Your Honor.
I'm wearing in solidarity of my criminal brethren.
Yes and no. Your Honor, she's gonna admit to the violation, but would like to be heard in sentencing.
All right, raise your right hand and place your under oath.
You solemnly swear or affirm that the testimony you shall give in this case shall be the truth, the whole truth, and nothing but the truth, so help you God.
State your full name for the record.
Miss Ann Turner.
You are here today charged with violation of probation, if I understand correctly, and it's been indicated you want to enter a plea today. You understand that you have a right to plead not guilty and to have a hearing in this court where the state would be required to prove to the legal standard that you have violated your probation. You understand that if we had that hearing, you'd have the right to have a lawyer and to have one appointed, as I've done with the public defender. You understand that if we had that hearing and I found you guilty, you could appeal anything I did in your case to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal. You understand that? You understand that by entering a plea of guilty, admitting your violation, you're preserving your right to have an appeal from whatever sentence I might impose,
Yeah,
but
these
you're
are the
waiving
people
your right
that
to
are
contest
driving in
whether
the
or
car
not you
next
have
to
or
you.
have not
They're
violated
taking
your
out
probation.
the checkout
You
line
understand
with
that?
you. These are
You understand everything I've explained to you?
driving down your
You
neighborhood
want to waive your right
streets,
to the hearing on the issue of
picking
your
up their
violation of
kids in the
probation.
same line that
simply
you
go to
are at
sentence.
school.
Yes, sir.
And I find you guilty of violation of your
When they
probation,
screw up,
we will conduct a sentencing.
this is
hearing
where
at
they
this
go.
point. Do you want to put on your proof? Do you want to put on your proof first, State? Mr. Warnick, or I'm sorry,
Mine.
Mr. McLeod?
She can go first, Your Honor.
Right,
I was going to reply, Your Honor.
right. Come around, please, ma'am.
And this guy's got it all. Look at this.
All right.
Now, this judge,
I'm
he
gonna take
goes
this
to like 4
performance
different
test. I'm gonna
counties.
testify.
All right, thank you, Your Honor. Can you state your name for the records?
Miss Deanne Turner.
All right, sir, you just admitted to violating your community corrections, correct?
Correct.
Now, where have you been residing?
I have been residing at, you know, the address,
No, just what?
in Bradford, Tennessee.
And you're reporting to Ms. Northcutt there, is that correct?
No, I actually go see her in Humboldt at the police department every week.
She's gonna have to speak up. Put the microphone.
Move that closer to the microphone. Is the microphone on?
Yes. I can get right on it.
You have to kind of get right on top of it. So.
I see her at the Humboldt Police Department. I'm supposed to see her at the Humboldt Police Department every week.
And do you have medical issues?
I have a lot of health issues, yes, sir.
Can you explain to the court what those?
I got
health
all the
are?
issues.
Insulin dependent, so I have to.
Yes,
use a
Emily.
insulin
I
pump
did get a haircut.
to keep my insulin regulated in my body. I have gastroparesis where my nerves are dying in my intestines. I have spider bite on my leg that's rotting my leg currently.
I have a
supposed to have
spider bite
surgery
that's
for it
rotting
on
my
the 17th
leg.
This month. My kidneys are in failure due to my diabetes being uncontrolled for so long. Amongst several other medical conditions.
And have you been seeking medical treatment for these conditions?
Yes, I've been hospitalized and had 12 surgeries this past couple months. It's 6 months I've had 12 surgeries.
Right. Based off of all of these medical conditions, is that why you did report?
Partly, yes.
And as far as why you've been in the jail, you've been receiving medical treatment through the nursing station there?
Yes, they're trying to help me the best they can.
Before you were incarcerated, where were you trying to go work?
I'm considered disabled.
Okay.
Because of all my medical conditions. So I was not working, but I was gonna open up a rehab. I have 4 sponsees underneath me. I've been clean. I have a sober date from 4/5/2019.
And was this something through the Hope Center or through
Yes.
another?
When I spoke with Miss Michaela, she said that the Jackson Hope Center had shut down, and that I could start an apprenticeship and get
Hey,
it
Cat Ninja, how
reopened
you
and
doing?
start helping people in recovery there in Jackson, Tennessee.
So that's what your goal?
That was my goal, yes.
Okay, and then obviously you were incarcerated due
Yeah.
to this violation.
Yes, sir.
Are you asking the court today what are you asking the court to do today?
I would like a chance. I understand just about the whole
It is good
month
to
of
see
August,
folks
I
out
did
here.
not report, but I did keep in calling and text messages and everything that I could do at that time. I've been reporting every week for 4 years, every week. Without any hiccups, without any dirty drug screens, without anything. Been slowly paying all my fines, but it's like I have to juggle whether I either go to see a doctor or I go to community corrections. And because I've been on house arrest for 4 years as well and not had a hiccup. This was literally my health being really bad and last month.
So, and I just want to clarify something for the
Okay.
court. But you went on to community corrections December 3rd of 2019.
Yes, sir.
Correct? Your violation was filed August 28th of 23 is when Judge Wallace signed that.
Yes.
So during that time, you were not violated until this one violation.
And so,
Correct?
yes, correct.
So you did an extensive amount of time on community corrections.
Yes,
All right, now, as far as you've admitted to your violation, so
Yes.
as far as drug screens, missed time, that's what you admitted to.
yes,
But you're saying during that time period, you were doing well in community corrections.
Yes,
And you're asking the court to reinstate you to community corrections day so you can help other people. And
I've changed, yes, sir.
is there anything else you would like to inform the court?
Yes, I understand that back in 2018, 2019, when my charges occurred, I was a different person then. At that time, when the court had sentenced me December of 2019, and I completed a 1-year-long program at the Doors of Hope. And I did the training to become a peer recovery specialist for the state of Tennessee. All I can say is, yeah, I was a very bad person back then. I was a monster, but I'm not anymore. And I help people in recovery every day. I'm on the national list where they need help at 1 a.m. in the morning. I get calls from addicts that are begging to get clean. I know I've changed. I'm a different person, and I just want the courts to see that.
Oh boy, it's gonna be interesting when Haley talks.
You have questions, John McLeod?
Yes, a few. Hello, Ms. Turner.
Hi.
I just have a few questions for you
Yes, ma'am.
based on your testimony just now. And I'm just asking you these for the purposes of whether or not you should be placed back on community.
She's
corrections.
19.
You did go on community corrections in December of 2019, correct?
Correct.
And in your testimony is you had no violations until this year.
Correct.
And this is your first violation.
Yes, ma'am.
And I believe you testified that you missed in August of this year.
I missed several dates throughout the year, but it was either for surgeries, doctor's appointments, or I had no vehicle at the time for the past month of August.
Okay, would you agree that you missed on March 7th,
Yes,
23, April 4th, April 18th, May the 2nd, May the 16th, July the 5th, July the 25th, and then of course August, as you've already said.
yes, ma'am.
And did you ever reach out to your community corrections
Every
officer and
time.
tell her why you couldn't make those appointments?
Yes, ma'am, every time.
Okay.
I stayed right in contact with Ms. Northside with emails, text messaging, and calls.
Okay, so you told her every single time that you couldn't make an appointment.
There was 1 or 2 times I did not, and that's because one of them, I literally, no one woke me up and I was asleep. I just had surgery prior. And the other one, I think I told her I was giving up.
Mm,
You told her you were giving up?
that's not
Yes,
good.
ma'am.
What do you mean by that?
I was giving up because it's like, we were trying to get it to where I could start going every other week, because I've been on it for so long. And I explained to her with my abusive relationship that I was in, and I had nowhere to go, I had nothing to do, and I said, the best place for me at that time, I said, was 3 hops and a kite at the jail. And that's my exact words to her.
Okay, so what has changed between then and now?
I've got my support from my family. They've seen how hard I was doing and all the work that I've been trying to accomplish and do it on my own, but I couldn't get away from the relationship that I was in. And now he's gone. My sister's got my stuff. My vehicle's fixed, and I have my backbone back. I have my family.
Okay, did you say you were under house arrest?
I've been on house arrest since December of 2019.
Okay, now you're talking about being on community corrections.
Yes, they're house arrest. I'm not allowed out of the house past 5 p.m. and someone comes randomly whenever they're told to come pull up in my yard, call me. I have to come out and I present myself. I know Ms.
Present
Northcott tried to
myself.
get it to where I can come in every other week because of the strain and me being on a limited budget.
Yeah.
But we can only do, she can only do what she could.
I understand that. You didn't have anybody that could give you a ride to her office?
My brother-in-law is a paramedic EMT for Jackson, Tennessee, and he works long strenuous hours. My sister does not drive.
But you understand by going on community corrections, you went over the paperwork with
Yes, ma'am.
your
Hey,
community
Jackpot, how you
corrections
doing?
officer, and you knew that you were gonna have to report multiple times a month, didn't you?
Yes, ma'am.
And I want to talk to you a little bit about the positive drug screens that you had.
Yes, ma'am.
You had one, I believe it was on July the 11th,
Yes, ma'am.
2023. And that one was positive for meth, amphetamine, and MDMA, correct?
Defense attorneys, you always take half up front, and then the other half you get paid before you go start the trial. If they don't pay the other half by the time you start the trial, you walk away.
Use the restroom all the time, like when
That's what I was
there's
taught.
sometimes I can't go to the bathroom maybe once or twice a day. And she had gotten the mouse swab kits for me. where I can at least drug screen. And we tried one, we just didn't do it properly. It was the first time we both used one.
But is it accurate to say that on February 7th and February 21st of this year, you refused to provide a drug screen?
Yes, and I had documents from a doctor.
Yeah, don't do drugs.
So you refused with her?
There's
correct?
no
Yes.
good drugs. There's no, okay.
I believe you testified that you have significant health issues. Like you said, you had diabetes. And do you think it's good for you to be using drugs while you have that diagnosis?
I hadn't used any drugs, man.
Well, you just testified that you had a false drug screen.
Yes, I did. I had a failed drug screen in July.
So
I
you-
cleaned out,
So you weren't using drugs even though you had a failed drug screen?
correct.
Okay,
Can I explain?
if you want to, sure.
Yes, ma'am. The boyfriend that I was with for a while, I had ended up
That
going. and
boyfriend
cleaning out
did
the
it.
property. It was a mutual, it was a bus, basically is what it was. And, I was cleaning it out because I had finally gotten him gone.
And
And
that's why you tested positive for meth, amphetamine, and MDMA,
yes, ma'am.
Hmm.
just in playing device.
It was a lie.
It was a lie.
Meth,
Yes, ma'am.
MDMA, and what else?
I didn't know it at the time until, I'm not no drug cook, okay? I didn't know it. But I explained it to her, and I also had the black and white text message of him saying he was going to make sure
Well, that's cool.
that I went to prison if I wasn't gonna be with him. And this,
Okay.
saying
Okay, so you didn't fail a drug screen because.
Do
you
it for a
used
hobby.
that. Correct.
Don't do it for
I haven't been using drugs.
thinking it's going to be a career.
And you
And you'll
refused to provide a
succeed.
specimen also because you're not using drugs.
My kidneys, yes, ma'am.
And also on this violation, Ms. Northcutt states that your fees to community corrections, they were reduced from $45 a month to $15 a month to help you out, but you haven't been paying on those, have
No,
you? You owe
and that's a mix. I think it's $200 some dollars I owe her.
$210. Would you agree with that?
Yeah.
And would you also agree that your court costs, fines, and restitutions have not been paid on since December of 2022?
Well, in this county, I have two different counties. My charges were all ran together for Dixon and Humphreys when I was charged. I did pay Dixon County. I didn't know I had to pay both counties every month. That's my mistake and that's my fault. Yes, ma'am.
And you would agree that you owe them right now over $7,000?
Something like that. Yes, ma'am.
Jeez. That's what kills about this stuff, man. That's why I feel bad for people. Is you got to pay court
So can
costs.
you tell us why you feel that you would be a good candidate to be put back on community corrections at this point? in
I
time?
stream on Twitch every
Yeah.
I've
video
changed. I
and
understand
never
I've
got
got
any
that-
type of
That
traction
one
on
dirty
it.
drug screen or whatever, but I'm paying the price anyways for my health from being a drug addict for as long as I was then. And trust me, it's taking a big
Yeah, the
toll
other
on my
shoe's
body.
going to be when this
And
Haley
I-
woman
I
starts
go to my
talking. I got a
doctors,
feeling.
I do my medicine. I try to show that no matter how cloudy or dark it gets outside, there's still hope. There's still light. You just gotta find it. I had a bad 2 months, and I learned the only way that I'm gonna get better is by reaching out and asking somebody else for help instead of me always being the helper. And I know Miss Northcott, we talked, and she
I need an
understands
inflatable
and she's
pool.
willing to help me. I have my sister on board now. I'm not trying to hurt nobody. I'm not out here doping and drugging anymore. I'm just trying to live.
Doping and drugging. I ain't out here
So,
doping and drugging
I guess my
anymore.
question is, why did you admit to violating community corrections?
Because I did what was stated. I did not go when I was supposed to because I did not have a vehicle or because I was in the hospital. It's no one else's responsibility but my own.
And you would admit that you also violated by failing drug screens, correct?
I have the one dirty drug screen that got sent off and then sent back saying that there wasn't enough for a specimen to even be tested.
And you know that when you refuse to provide a drug screen, it's the same as failing.
Yes, and that's why I brought in my doctor agreements as well. Ms. Northcott knows that. My doctor's told her why I can't just go that. That's why she got mouth swabs for me.
So you're saying your probation officer violated you knowing you had a medical condition for failing.
She
drug
did her
screening?
job.
So her job is to violate you? for
No,
failing?
her job is to make sure that I'm doing what the courts have asked me to do on community corrections. And I was not doing that correctly because I have various reasons, mainly my health. She did her job above. She's always been there.
Okay, all right, no further questions right now. Your Honor.
Redirect.
No, Your Honor.
Thank you, ma'am. You may step down. You have a seat. Let me ask this question before you go. Tell me again what all your medical issues are. I know you said you have to
I
take an
have-
insulin pump.
Yes, sir. I have type 2 diabetes. I'm insulin dependent. I have gastroparesis, where my nerves are quit working in my intestines. I've
You have to
taken,
take medication for that.
yeah.
Okay.
I've started with my kidneys are starting to show signs of failure. So they started new medicine called Corindia to try to reverse.
And where do you get that medicine?
I get it at Walmart and Bradford. My endocrinologist prescribes it. I see a specialist.
And
You did
you
a
fill
really good
that
job of
through
that.
Walmart
Appreciate that.
And
pharmacy?
yeah.
And then how much does that usually cost when you fill that pharmacy?
me, just $3.
So you have a copay or
That's my
Is it-
copay. I have insurance.
insurance through who?
Social Security. I'm disabled.
And
I'm
you're
sorry, through who?
Social Security. She
I'm
said.
sorry. Social Security, and that's Medicare, Medicaid.
Medicaid, yeah.
Medicaid. And are you classified right now as disabled in Social Security?
Yes, sir.
And on what basis?
Due to all my different health conditions.
All right. Thank you, ma'am. You may step down.
Thank you.
Mr. Hooper? Defendants has rested their proof. Gentlemen, do you have any proof you wish to offer?
I'd like to briefly call.
Right. Ms. Northcott, if you will raise your right hand, let me place you under oath. Do you solemnly swear or affirm the testimony you're about to give in this case will be the truth and whole truth and nothing but the truth?
I do.
Thank you.
Hello, Miss Northcott. Can you hear me? Or Northcott, I'm sorry. Can you hear me okay?
And
How do you guys feel about letting them
Could you
do
state your full name
Zoom
for this
to
court,
come into
please?
court?
Haley Northcott.
Where are you employed, Miss Northcott?
I am employed with Community Corrections, Corrections Management Corporation.
And do you currently have Missy Ann Turner as? a
Probation.
I do.
client? And how long have you been supervising her?
I took over her case August the 1st of 2022.
And did you hear?
Which one
everything
did you
Ms.
like,
Turner
Fofa?
said?
I did.
Bofa? I can't talk anymore.
And in your experience, did she report regularly prior to getting this violation?
There were times that she was in the hospital, times that she was at doctor's appointments. I would say probably 90% of the time I did have verification. She would send paperwork, and those I would excuse. The ones that are listed on there are the ones that I did not have documentation for, any doctor's appointments or hospitalization. Those were unexcused absences.
In regard to Ms. Turner's drug screen, did she provide you with some kind of medical verification as to why she couldn't take a drug screen?
I had several medical records from Ms. Turner. There were some stating that she did have issues going to the restroom. In most cases, we would have to go in front of the judge and have drug screens omitted to be able to not let that be a violation. And we were not at that process. We had ordered some oral drug screens, and I attempted one on Ms. Turner the very first day that I did get one, and I was unsuccessful on my own part and have since had actual training and certified in completing an oral drug screen. So I do have those.
In the 2 times in February, when she refused a drug screen, was she able to do the drug screen that you were offering?
Not at that time. I only had urine screens. Now she did write detailed information on there as to she's unable to provide a urine specimen due to medical conditions, not able to go on demand, sometimes stating that she hadn't been to the bathroom in over 24 hours. It was an extent as to what her reasoning was not being able to provide a specimen at that time. But anytime that we were doing drug screens, we would have to have some kind of documentation if they did or if they did not take a drug screen, either a negative or a positive screen or a refusal, some type of documentation stating that I did attempt.
Okay. I guess I'm just trying to clarify the 2 dates that you have on the violation.
Mhm.
February 7th, February 21st. What were the circumstances of her refusal on those dates?
She just stated that she was not able to go to the bathroom during the time frame that I was there at the office.
Okay, how long were you there?
During that time, I was there from 9 in the morning until 12 at lunch.
Okay. And on these days where she missed, starting in March of this year, going through the end of August, did she meet with you at all during that time period?
Yes, there were 2 or 3 times that I did not have any contact with Miss Turner when she did not come. I have a very detailed record as to whether she was at doctor's appointments or not, but no documentation was ever provided for the ones listed in the violation. Whether it was stated that she was at a doctor's appointment, if I didn't have documentation of it, I'd have no proof that that's exactly where she was.
And Ms. Turner did tell you that she didn't use drugs on the one positive drug screen, correct?
That's correct.
All right, no further questions.
Mr. Hooper? Thank you, ma'am. You may hang on, but you want to see what we do in this case, then you can stay, just remain as a observer.
Okay.
Do they have any other proof?
No, Your Honor.
Either side wish to be heard in argument?
Wait, Your Honor.
Wait.
Well, the court finds that she's admitted her violation. It is a first violation, so under the circumstances, it is this court's opinion that she has verifiable medical conditions that affect her ability to comply with some terms of probation. So I'm going to put an order down that finds that she is in violation of probation, but I will reinstate her on time served.
Yeah, tell him back again.
To community correct, or to, yes, community corrections is where she is, I believe. And I will order that all future drug screens be by the oral method that you are now qualified on, Ms. Northcott. Rather than that, any missed meeting that is missed, you're gonna have to produce some sort of verification. So you can't just call up and say, I'm not coming because I got a medical diagnosis or something else. You're gonna have to go get a written report from the doctor or something that satisfies Ms. Northcott, because this is a one-time consideration of your medical conditions that will give you to let you comply. You apparently done well for a period, and I want to give you another opportunity to do that. You've been in jail now for roughly a month, so we'll give you an opportunity to go back on community corrections to see what you can do. That will be the order of the court, and let's modify. Is there any, Ms. Northcott, let me ask you're her probation officer or community corrections officer. If I modify the requirement of her drug screens to allow it to be done orally and require that she provide you with verification of any doctor's appointment that requires her to miss a meeting, is there any other recommendation you would make to the modification of her probation with community corrections?
No, Your Honor, that would work well, I believe, for Ms. Turner.
That'll be the order of the court. Thank you. All right.
So she's getting kind of a
Do we have
second
anything else
chance.
before?
I mean, she still owes the court a lot of money.
Judge, we've got that one gentleman that's online, to get a trial date.
This is the,
Mr. Baskett, our attorney.
Yeah.
Baskett.
Oh, man.
He's still on there.
yes, it is.
And it's, Mr. Hornick said they don't generally handle
Oh, that,
we just need a date. Due care. And I believe the 18th, he had said before, he didn't think it would take but about 10 minutes.
Do it on December 18th.
December 18th would be fine.
Well, Mr. Baskett just left.
Well,
I had him in the waiting room and now he is gone. In any event, we'll set his.
Yes.
Sounds like
set
I'm to
that
be there.
citation.
I'm
We'll send
old-fashioned
notice
that
to
way.
Mr. Baskett that it will be December the 18th.
Of course, I don't think technology should be
Judge,
used in
this,
court.
Lennon's brought over Mr. Dainsworth, which is Mr. Flanagan's client. Still no one's heard from Mr. Flanagan. We'll just take him back and let us figure it
The
out.
only thing we can do is take him back. Mr. Flanagan is apparently trying a first-degree murder case in Trousdale County, and therefore he's not able to be here, and obviously can't pick up the phone during a murder trial and call us to let us know. But in any event, all of his cases will have to be reset based upon that fact that are set for tomorrow
And
or the next day.
I've got dates for those. Judge.
All right.
Judge, finally, Miss Cotton is here. This has been an ongoing,
Who is this? I'm sorry.
Wendy Cotton.
I didn't see what print you like.
Yes, sir, it is.
So Judge, Miss Cotton was originally placed on probation in 2015 on a conditional guilty plea. She had a large amount of restitution. She's paid that regularly, I think, in the notes. She's still got a balance, but she's paid faithfully. In 2020, her probation was extended for 2 years. She filed a pro se motion to extend her probation again, and I think that ended up being in front of you. In fact, it was on October the 11th.
Why is probation being extended?
Can't extend again, so just kind of left it going. Well, they didn't issue a new VOP until after her 2 years had expired. So she's actually not on probation. So we really just need to, and she'd asked me about this, just need to convert it to a civil judgment, whatever the balance is left.
Well, let me ask this question without looking at the file.
When I was file back, just I wanted to be able to be semi-intelligent when I spoke. I say semi.
I love these old lawyers.
But in my review of it, it looks like the second VOP
Yeah,
after
right.
the extension didn't get filed, so the
Volstorm?
2-year extension was over.
All right, well,
I was trying to think I've seen her over on Ladies
probation
Night.
was obtained in January of 2023, and that would have been beyond the scope. So she is terminated from probation because it's expired, and will convert whatever the remaining restitution is to a civil judgment. You can
Yeah.
continue to pay that, but you won't have to report to a probation officer.
So just for the record, so I know how our office handles the paperwork, she was on a
It is.
conditional guilty plea. So if she.
Probation is expired, it was not,
Totally is.
she was never found to be in violation, so the conditional guilty plea is still.
We'll do that order. I
Yeah,
just want to make
no.
sure we do that.
We
So,
won't be able to expose it until it's paid in full though.
okay.
I can't.
I think there's-
I can't.
I love that she's not saying anything.
That's
She's
why I
just
wanna
shaking
make
her
sure while
head.
We were here, so there was no
Why?
confusion.
So,
So as soon as you finish paying off the judgment, you can have it expunged.
Thanks, sir.
It says thank you.
All right,
That's
then we'll
it. And
come
she's
back at
out.
1:15.
I feel like
I
she
do have
thinks she
one
got
other
away with
client
something,
that
which I mean, she kind of did.
before lunch. It's not
I mean, they
a
weren't.
plea,
They were probably going to keep her on
Farlow.
probation or whatever.
Heather Farlow.
Let's do it now. Get it over with.
Oh,
Miss Farlow is on
Keep your
page,
hands out of your pockets, please, ma'am.
yeah.
bottom of page 3, John.
Right.
Miss Farlow was set for trial earlier this month, actually on October the 12th. And at that time, actually on docket call day, she did not appear for her final plea day. And information came to Mr. Hooper that I think maybe she was under the weather or something. I can't remember.
She was in Camden. She got her trial date mixed up. She was going to be here on the 12th. Forgot she was supposed to be here on.
There we go. So she was going to come to her trial day. The state had issued subpoenas. We were ready to go. She said she was going to enter a plea, and we reset it today for her to plead. Now she has decided she does not want to plead. And so we were ready to go to trial. Subpoenas were issued and served.
Wow.
Well, there is a basis upon which the court can find that that is obstruction of judicial proceeding and thereby revoke her bond and render her to custody. Based upon the fact that her trial date was passed solely upon representation, she was going to dispose of the case by plea.
Yeah.
So
Your Honor, hold 1 second.
What I'm gonna do is I'm gonna have her come back at 1:15 and
That'd
talk
be
to her
fine,
in the
Judge.
lunchroom. We'll decide if that's one of my options.
Where's 1:15 per your honor?
1:15.
Thank you, Judge.
So the judge just says, I don't care. I want some lunch. I can smell the cafeteria. Yeah, there's a meat and 3 next door to the courthouse. Like that there's no hit of the gavel or anything to dismiss court. We're just gonna come back in an hour. There you go. That's awful looking. Wow. So an hour. Oh, hey, you know what? Now's a good time to try this out. I have a new thing. How do I sign in?
You never know.
Oh, there we go. All right, so let's check this out. I have a game. I want to try this out. Never done this before. We're going to see how this works. And hopefully it does work. It'll be like an hour. Oh. Let's see here. I got to hit. Got save and then hit start. Wait, how do I do it? How do I do it? Oh, looky there. So that's not what I want either. It's crazy how that messes up. Hey, looky here. We have a game. Oh, wait, hold on. I got to get rid of my face. I don't know how to play this game. Can you find all the words? Yeah, he leaves the court like he leaves the streams. I love it. All right, let's see here. What is the word here? Oh. Hey, look at that. Fallstorm. You beat me. Oh, White Rabbit's in here. Now never win. Oh. How come these aren't popping up? Can you find all the words? Comment to guess. Oh, wait, hold on here. No, I don't understand that. Oh, that's a good one. I don't know if I'm spelling these things right. Oh, that's a good one, Jackpot. MLS, how you doing, Ben? I don't know any of these things. I found SOB. That count? Okay, so there's 9 words they're looking for, and there's 2 words with 5 or less letters above it here. Oh, those are all the words. Beach, artist, decree. Look at check. We both of there's been check was put there twice. Checkbook was what I was looking for. Well, this is hard. Okay, so see on the words, that's the length of the words. Holy cow, man. It helps that. I mean, I really can't spell at all. You know, here. Oh, Sage got it. It is. I see that. It is recreation. Well, that's not up there. Yep, it is. Look at that. Oh wow. Okay, so like yacht and recreation. I wonder if it's things to do with like fun. So like I see fault. I can be fault. Oh, motor. That's a good one. Something wondering if boat is up here or ship. Gallery. Oh, that's a good one. I'm totally confused. Man, I really am bad at these things. Oh wow, you guys have really gotten this one now. Holy cow. Boy, look at that. I think it's my unemployment is only worth 7 and jacket's worth 9. I don't know why it's making noise. Stop it. Stop it. Jesus, weird. 30 seconds. Result of round 5. And the final results are Jackpot Springs. You, the winner. I don't like that. That's weird. How much I don't like that. Congratulations, Jackpot. Congratulations. So what'd you guys think? Need to work on it? Yeah, it was. That was hard. I didn't get so there's let's see here. Let me see if there's another. Oh, that's cool. Okay. I'm gonna try one more here. What do you guys think? So all of these will be food and drink. Why isn't that game bigger? Whoops. Whoops. Sorry. Okay, so yeah, it was evil. Yeah, I didn't like how hard it was, but the next one we'll have the category be all food and drinks. You want to try that? Let me get my big old fat face off here. Why is it like that? You know, you used to not do that. Oh, we have so all these are food and drink. Food and drink. Okay, these are all food and drink categories, and I will be right back. Hey, look, there I am. Hope you can get a shave and found out that the White Rabbit was he's going to close these out. And we will go back over to our wait, is that not it? Where's the thing? Crud. I'm always hitting the wrong button. Sorry. There it is. Okay. Well, it's not sharing it. There you go. People are starting to walk around. Come back in. Be like, hey, how you doing? What'd you have for lunch? Did you get the sweet tea? Oh, it's good, isn't it? Yeah, it is. You guys like that? How I add the commentary? Oh, this doesn't look good. That's a cool shirt. Oh, crud. All right, let's see here. All right, they're still talking, moving around, doing that whole thing. Oh man. I'm supposed to take like vitamins or something, aren't I? Where are they? Gotta take my performance pills. That's not it. Nah. Might be it. Oops, not that one. The unshot off. That sounded weird. You know, yeah, sweet tea's the greatest. Holy cow, I know. I'm gonna have to check out how that thing works. That was the first time ever trying it. I wanted to see how it did. There's another one's like find the animal. And it's like it shows like what looks like a human, but they're put together by animal pieces. Some of these things you have to think, oh yeah, they were designed in Japan. Come on, Humphreys County. We got stuff to do. My leaves have not fallen off yet. And I need to mow them. Oh, you didn't like the music? I didn't know. The second time I was like, oh, look, there's music. Maybe that'll be. I didn't even know there was music first time. Or like there could have been music. I think I just drooled. I don't feel like drool, but I think I'm having a stroke. I'm just gonna have a stroke right on over here. I need a footstool. That's what I need. There you go. Oh, hey, you know what? Check this out. Oh yeah. There we go. And pull this. Oh yeah. There. Now. You guys wake me up when it's over. Oh, it's not gonna fit. There you go. If you guys see me like this, I assure you I'm not asleep. Oh my gosh. So tonight we'll be hanging out with Waifu Kron. I've been wanting to interview her for a while because I did a stream with her and she's really cool. And she picks up on things. I don't know if it was just me or if other people notice it. I think you will have a good time. I have no plain questions. I don't do that. I just go with the flow. Y'all know me. So it'll be interesting, to say the least. I get the White Rabbit to do a thumbnail for me. If she was listening, she would know. So I'm going to hit her up for a thumbnail. But it'll be a good time. Waifu's a redhead, so she of course fits in over here. I don't understand what it is with redheads and this channel. I'm not complaining, but I just think it's unique. Maybe I've never known redheads. I don't know. It's just like, oh wow, there's a lot over here. What is this? Oh, that's cool. No, I don't want that. I didn't know I could adjust my Apple News. Okay, now here's what I don't want. I don't want. How do I edit it? Oh, that's so cool. don't want that though. How do I get rid of? I don't want special coverage on here. I don't want it to be of climate change. Oh, there you go. I'll take that off. Oh, awesome. Something strange is happening to golden retrievers. The military has a skinny fat problem. What is a skinny fat problem? Every day, people call her and she listens as they overdose. Well, that sounds like a fun thing. Every day, people call her. She tells them to unlock their door, put her on speakerphone, and use their drug of choice. What a great person. I don't know how to do that. What is this? Oh, here comes the judge.
Let's take up Mr. Hooper's client.
Yeah, sure. I spoke to my client, Your Honor. My understanding is she's going to enter the plea that originally we had discussed.
That's too hard.
All right. This is Miss Heather
It's a
Farlow,
crossword mini.
docket number 14609. And the agreement that I've been handed is that she's going to plead no contest to count one, which is 10 care of fraud, a class D felony, receive 2 years probation or 2 years Department of Corrections suspended of probation. With count two, she would have 3 years suspended of probation, concurrent with count one, costs and restitution of $10,000 to 10 care. She would be disqualified from participating in 10 care. As
Wait, he's talking. How come I don't hear him?
All right, Ms. Barlow, raise your right hand. Let's have you placed under oath.
You solemnly swear
because I
or
don't
affirm
have
that
the
the
volume turned
testimony
up.
now given in this
Oh, I'm
case
not
shall
wearing
be the truth, the
earphones.
whole truth, and nothing but the truth.
Duh.
So help you God.
State your full name.
I apologize.
Had one last meal before going to jail.
$10,000 is a reduced amount that we've agreed to as part of the criminal part, but the Department of 10 Care can seek a civil judgment for the rest of that. I assume Mr. Hooper knows, I think he's explained to her. I just wanted to make sure that was on the record.
There's a difference between restitution in a criminal case and a civil judgment, so I'm sure that Mr. Hooper's explained that. Ms. Barlow, state your full legal name for the record. Ms. Barlow, you're here today charged with 2 different counts of 10 care fraud. I want to make sure you understand your rights. Have you seen or been shown a copy of those charges? Talk them over with Mr. Hooper. Do you feel like you fully understand what you're facing and the range of punishment you're facing and so forth?
Yes.
Well, it's indicated that you want to enter a plea of no contest. A no contest or a nolo contendere plea means that you understand what you're charged with. You're not going to admit you did anything, but you're not going to deny it. And as a result of that, the state is going to give me facts in a little bit that will show that show that you are in fact guilty of that, even though you haven't admitted it.
I'm going to get through this.
I need you to answer verbally because we're recording everything that's being said. Okay. Do you also understand you have a right to plead not guilty and have a speedy and public trial by jury?
I appreciate you, Mimsy.
You understand if you
I like
went to
knowing
trial,
breaking
you
news.
have the right to have a lawyer and have one appointed for you if you're unable to hire your own. Yes. You understand that if you went to trial, you would be presumed to be innocent until such time, if ever, the state proved your guilt beyond a reasonable doubt to the satisfaction of all 12 jurors, and their verdict would have to be unanimous before you can be convicted of anything. Yes. You understand that if you went to trial, you and your lawyer could confront and cross-examine every witness the state called to testify against you, and you can bring in your own witnesses by the use of a subpoena. You understand that if you went to trial, you would be presumed to be innocent. You would not have to testify or prove anything, and there would be no inference of guilt arising because you did not testify at your trial. You understand if you went to trial and you were found guilty, you could appeal the conviction and the sentence imposed to the Court of Criminal Appeals and have a lawyer appointed to help you with that appeal. You understand that by entering this plea of no contest or nolo contendere, you're waiving your right to a trial and to an appeal. All I'm going to do is approve what your lawyers worked out with the state. You understand that's going to result in 2 convictions, and those 2 convictions will be on your record in the future to make more severe the punishment you'll receive if you're ever again convicted of a crime. You understand everything I've explained to you?
Yes.
Do you want to waive your right to a trial and to an appeal by entering a plea of no contest pursuant to this agreement? Is your decision to plead no contest today voluntary?
Yes.
Anybody forcing you to do this?
No.
You understand I can't accept your plea unless I'm satisfied there are facts to support a finding of guilt in your case. And I want you to listen as the state tells me what their evidence would be if this case went to trial.
In this case, if you're done with trial, the state is expected to show that Ms. Barlow has 2 biological children. Those 2 biological children were placed in the custody of their grandmother by the Humphreys County Juvenile Court. After they were placed in the custody of the grandmother in July of 2016, on September the 15th of 2015, Ms. Barlow received approval of TennCare benefits for both herself and her 2 children. Those benefits were used for a total amount of $28,036.39. If Ms. Barlow had used she was not eligible to claim the 2 children for TennCare, and if she'd used their correct custodial information along with her correct income, she would have not been eligible to receive TennCare benefits.
And I'm not asking that you agree with those things, but do you understand that that's what the state's evidence would be with this if this case went to trial? You still wish to enter a plea of no contest pursuant to this agreement?
Yes.
Are you satisfied with your attorney's services?
Yes.
Believe that Mr. Hooper's done a good job of representing you confidently. Mr. Hooper, do you know of any reason you should not?
So no contest. She's saying that she doesn't
And Heather Farlow,
agree
docket number
or disagree with the charges.
14609, upon your plea of no contest to count 1, I find you guilty of TennCare fraud, sentence you to 2 years, Tennessee Department of Corrections, suspended to probation, order you to pay costs. Count 2, theft of property, I find you guilty, sentence you to 3 years in Tennessee Department of Corrections, that will be suspended to probation in order to pay the court costs and restitution of $10,000. And you are disqualified from participation in TennCare in the future. All right, thank you.
There you are.
TennCare fraud, was that it? But she didn't go to jail, did she?
All right, is the only other matter then what we have is Tori A. McConaughey. McConaughey.
I mean, they didn't have to go to lunch. You realize that, right?
All right. So we're waiting after this to deal with that. Correct.
Yes.
Well, this matter is set for trial tomorrow. And a motion to continue was filed on Monday, the 23rd.
TennCare used to be such a ripoff, man. There is a person from St. Petersburg.
Right.
And I love it. They always used to say, not Florida, but Russia was on the rolls.
I filed a motion to continue in this matter based on the reasons outlined in the motion. Court will recall we were set for a trial back in April of this year, and General Hornick received some data from the black box involving the automobile crash in this case. And immediately upon him receiving that, he turned that over to me, but it was late as we were set for trial that week, I believe. And I asked the court to continue it at that time for me to have time to look at that and possibly employ the services of an expert to assist me in
Services of
analyzing
an expert.
that data from the black box. as we felt it was possible that it would contain evidence that would tend to show reasons for the crash beyond the reasons stated in the indictment as far as the alcohol and other intoxicants. So we were unable to secure those services. I was working and was being assisted in trying to obtain that expert.
Your cars are
Another,
telling on you.
Local member of the bar, and I was told that the expert that hopefully I was going to be able to use had a recent diagnosis and would be of ALS and would be unable to assist. And so it left me with very little time to try and find another one, which I was unable to do. So that's the basis. I would like additional time to try and obtain an expert to assist me with that matter. Your Honor, the matter has been reset. This matter has been reset a few times. I recall a time when General Arnold was prosecuting the case and there was a witness that was unavailable. I think a medical examiner was unavailable, that it was continued. Another time it was continued because some more additional discovery was discovered that hadn't been turned over to me. The time that I've just relayed to the court, and then most recently, we were set the beginning of this month, and the matter was reset by agreement to tomorrow's date. I believe again because the state had a witness that was unavailable at that time. So I don't feel that the defendant has asked unreasonably for continuances in this matter. I feel that it's necessary, and I would ask the court to continue the matter. And if so inclined, to set a deadline, a line in the sand for that expert person to be identified and turned over to the prosecution in order for them to have a time to obtain their expert if they were so inclined. Thank you, Your Honor.
Judges, as you know, this case was set in April. And just to go back, I looked back at the docket sheet to look at the times this has been set. From my reading of the docket sheet, and Mr. Sanders is correct, General Arnold had this at one time, but it shows that there was a defendant's motion for a continuance. One time the state moved for continuance. Then in April, we moved this by agreement. And I'll touch on the agreement to move it from earlier this month to tomorrow in a moment. But Mr. Sanders states in his motion for new trial, or excuse me, for motion to continue, Your Honor, that he has not been able to secure an expert to assist him in analyzing crash report data information provided to counsel. Expert knowledge testimony is critical to this case and absolutely necessary.
What's it? Every time they say expert,
Just
I
a brief outline.
want to
Judge.
jump and look up.
This case, as you know, was set in April, and we actually had the black box data. We were unaware that Mr. Sanders did not have that. And actually turned that over to him, and by agreement said, absolutely, we didn't want to do that, but actually couldn't oppose that because understood he needed to have time to analyze that data, to review that data, to look forward to it. The state, I immediately prepared subpoena letters so we could have the medical examiner here in October, so we could have everyone here. We issued those subpoenas for a variety of reasons. Some of those subpoenas didn't get served for several months. And in August of this year, one of the persons got served as an eyewitness to this incident. And he contacted our office and said, I already have a prepaid trip. Now, we had issued the subpoenas in May. He didn't get served
Prepaid
until
trip.
Late July. So I immediately reached out to Mr. Sanders and reached out to him and said, can we reach out to the judge's office and see about moving this to the end of the month? And that was in August of 2023. Mr. Sanders told me, hey, that's good. I don't have an expert anyway. I have not been able to find one. So I don't mind. So we reached out to your office. We kept it in the same term. If you recall, it was specially set on October 3rd. We agreed to move it to tomorrow to accommodate that eyewitness who had been served
Yeah.
way before.
This is the
10 days ago.
unsexy part of law.
So
This
we
is the
agreed
part
move
you have
that.
to
We didn't agree
understand
on
to.
it.
We
Then
have
in
all these.
September, Your Honor,
I don't know
I
how many
reached out to
people
Mr.
that
Sanders and said,
watch
hey,
trials would ever do the background,
if
the
you have an
crime part.
expert, we've requested that under Rule
But it's
16.
so
We need time to get
tedious.
our own
Like,
expert. This
I have
trial's
a
month
OCD
away.
thing. I think
Where
about
are
doing
we? Mr.
trials.
Sanders reached out to
We
me
got
and
to
said,
know
I don't
all
have an
this
expert.
background and
I don't have one.
everything.
I said, okay, so we're still good. Yes. Then last Monday, I reached out to Mr. Sanders and said, hey, do you have an expert? We hadn't heard anything. I need his reports, opinions. We have a right to have an expert. He again told me he did not have an expert. He mentioned then
You should always
that
have an expert.
he had possibly gotten the name of an expert. I immediately responded to him, have you retained this expert? His
Nope.
response to me was, no, I have not retained this expert. We talked by phone. He said, I have not retained him. I got his name as a referral, but he's got ALS, so he can't help me, and I don't have an expert. And I said, so we're going to trial. He said, yeah, we're ready for trial. Your Honor, this has been 6 months that he has had to find an expert. Maybe there's not one. I don't know.
Oh, there is
Do
one.
you have an expert that you intend to introduce this black box information with?
The person who would introduce
Not a black
the
box
black
expert.
box information.
I'll be your
would
expert in
the
anything
trooper
else. I'll
that
make stuff up.
downloaded the
That's all experts do.
black box information.
Is he
Remember, it's
qualified
always
as an
their
expert
opinion.
to enter to opine as to what that information showed?
I think he is. I've not used him, but I think General Crouch has. And I'm not saying that we are or not going to
It's
use
very
it.
important, and that's the problem with doing trials. It's like
I do know
people,
for a
I think,
fact,
want
Judge,
that
in
big
just a
gotcha thing. They want that
short
Johnny Depp
search
where it's sexy.
that
And trials aren't sexy.
there are multiple police agencies in this district that have crash reconstruction experts that could have been reached out to. I did a quick Google search as soon as this motion was filed and found about 10. My point is that we've gone 6 months.
6
And
months.
I was told in August and I was told again in September that we didn't have an expert and we could not find an expert. So we're at 5.5 months, no expert. Now, 2 weeks before, we don't know the name of the expert. I don't know. I'm not denying that Mr. Sanders says he has ALS. I don't think Mr. Sanders has ever spoken to the gentleman.
Oh.
So here we are, less than a week before trial. We have to call the family and say, hey, we got a motion to continue. This thing has been continued 3 times, at least once for the defense. And Your Honor, we are ready to go. There are at least 15 witnesses that have been subpoenaed that are prepared to go. The family is ready to go under the Constitution and the statutes. Your Honor,
I love how
they
he's
have
arguing about
rights
it's being continued,
to a speedy trial
but
as well.
2 times where
And
the
besides that,
prosecution.
Your Honor, in State versus Victor James, and I'm spell his last name Cazes, 875 Southwest 2nd,
On
253.
continuance,
which
if
was
both
a
sides
death
agree,
penalty
they usually
case.
get granted.
The Supreme Court said
If you have a disagreement like
that
this, the
it is
judge
not an
will weigh
abuse of
the
discretion to deny
facts and come
continuance
to a
for
decision.
failure to grant that continuance for the defense's failure to secure experts. As the motion, and quoting that at page, can't find the page, 534, 530, bottom of 533. We observe that the decision to grant or deny a motion for continuance rests within the sound discretion of the trial judge and will only be reversed upon a clear showing of abuse of that discretion and prejudice inuring to the accused as a direct result of the court's ruling. That's after trial prejudice. We don't have any showing of any prejudice whatsoever that any expert will change the information or have a different opinion of this information that Mr. Sanders has had. They're not going to disturb any decision by the court unless they find an abuse of discretion, and that was a death penalty. That's a capital case, Your Honor. Likewise, the determination of whether provision of expert services to an indigent capital defendant is necessary to ensure that the constitutional rights of the defendant are properly protected is entrusted to the discretion of the trial court. In that particular case, there had been several continuances, longer period than this, I will grant. That case had several continuances, but that case is clear that it's up to the sound discretion of the court. I don't know, the state doesn't know, because as Your Honor is aware, funding for experts is ex parte, so we're not aware of that. But I don't even know if there's
Expert would like to get some
request for
funding.
yet.
How do I
So,
fill that
here
form
we
out?
are, the day before trial. And actually, I said last week, we didn't file the motion last week. The motion was filed Monday about lunchtime to continue the case that is set tomorrow. Don't have an expert, don't know who the expert was that's been bantered about, that Mr. Sanders has not talked to. Whether he has ALS or not, I trust Mr. Sanders. He says he does. But here we are again on the eve of trial, the family ready to go. We are ready to go. Everybody's ready to go. And there is no indication that he would be prejudiced by not having this. And the courts have said that it's in the judge's sound discretion. And we've had 6 months, Judge. And that's the bottom line. We've had 6 months for them to get an expert, and they don't have an expert. And this is a download of data. It's not, in this particular case, they were looking for psychiatric help. They were looking for stuff, Your Honor, that's objective, that people can have different opinions on. This is scientific numerical data. I don't see how, if it's introduced, how it could, he's not shown that he's prejudiced by this or by not having an expert. And the court has said they're not going to disturb it unless you show an abuse of discretion. And we don't think it's an abuse of discretion, Your Honor, to go forward. The family's ready to go. We're ready to go.
Evidence.
And I think the case law is clear.
It's just
that
hard.
It's not an abuse for
It's
you.
a long and
move us
tedious
forward
process
tomorrow
and just
out there
takes a lot of
or
repetition.
Anything further, Mr. Sanders?
And then you get something like right now, it's real popular to say facts not in evidence. I'm like, what are you guys talking about? That doesn't make sense. I don't remember that. And you go back and I start looking through things. I'm like, it's called assumption. You can't assume things. You don't do these fans. Everybody wants to be, oh, I'm the smarter attorney and stuff. It's like,
I wish
just keep
that I
it
had
simple,
relied
guys. That's how I was
that
taught.
expert would be available, and I found out late that he was not going to be of any help or even available to me at all. So I don't know what to say, except we have no expert as we're sitting here today, and I would like time to try and find one. Mr. Hornick mentioned that he doesn't know if one's out there, and I'm assuming there isn't such an expert that would study this data and be able to tell us better exactly what it says was occurring at the time of this crash. And I would like additional time
I mean, if the car had a
to
problem
locate that person.
and they're able to identify it through this black box stuff, then they ought to, they'll be allowed to do it.
These are difficult decisions for the court because it's always requires the court to balance the interest of speedy trial rights of the defendant with the speedy trial rights of the victim or the victim's family in these situations, and trying to ensure that not creating an issue that could come back to result in
Assumption.
a retrial of the case if the Court of Appeals was to decide that I made a bad decision. In this
That's
particular
the fact right
situation,
there.
I have considered this issue since I learned that there was a motion
an
to
issue.
continue being filed, and I wanted to kind of give it considerable thought and be able to make a rational decision. And here's where I arrived. Number one, this issue arose in April, 6 months ago, and at that time, the issue was about finding an expert to interpret the black box information off of this vehicle.
All you have to do is
I had no
download what
problems
it
in
says,
continuing the
and
case.
somebody reads it.
We,
You know, that's all the
unfortunately
expert
have
has to
continue
do.
too many cases as it is. But I continued it in order to give Mr. Sanders an opportunity to locate an expert if he chose to, or to analyze the data. There is the black box information, if I understand correctly, is only going to show information regarding the speed of the vehicle and so forth.
Yeah.
And the operation of the vehicle, perhaps. The affidavit of complaint that originated in this case in February the 10th of 2021 states the following. On February the 10th, 2021 at 13:44 p.m., Carroll County Sheriff's and Humphreys County Sheriff's Office entered the city of Waverly in a vehicle pursuit with a stolen vehicle. I deployed stop sticks near Twin Lakes on Highway 70 West. The pursuit continued on Highway 70 West. The stolen vehicle then crashed into a vehicle at the Clyden intersection. The suspect was found to be Troy McEnany. McEnany appeared to be under the influence of methamphetamines. In plain view, I saw hypodermic needles in the driver's side floorboard, digital scales, a glass smoking pipe, and a white plastic baggie with white powder residue inside of it. I found several open beer in the vehicle. McConaughey was revoked for DUI and had a DUI on his record in 2018. McConaughey's crash caused the death of 2 citizens that were in the vehicle. The indictment in this case charges the defendant with vehicular homicide by driver intoxication, 2 counts of vehicular homicide by recklessness, evading arrest, DUI, 2nd, revoked license, 1st, driving unlawful drug paraphernalia, and 2 counts of reckless endangerment. It is this court's opinion that there is no evidence in the record to establish that there is an expert available that would in any way determine the information from this black box that might be exculpatory in nature. Based upon the nature of these charges and the type of charges they are and the factual scenario that's set forth, which I cite only because that was what led to the original charges, and I'm assuming will be somewhat of an accurate recitation of the facts that is coming. In this court's opinion, 6 months continuance is sufficient time to have concluded any kind of pretrial investigation and preparation for both the parties, and therefore the motion to continue is respectfully denied. The case will go forward tomorrow morning at 9 o'clock.
Ooh.
Anything further before then?
No.
Before we adjourn?
We're adjourned. We are adjourned.
Bench conference quickly before you adjourn today.
All right, well, let's take the bench. Is it on the record or off the record? Then let's go to the jury room.
Mr. Nyhoff will be a new trial date.
All right, well, let's go ahead. You want to go ahead and give him a trial date now then?
And I've got Madam Clerk pointed out, there we've got several that I'll announce.
Well, let's just, if you don't mind, let's give Mr. Nye, he's been waiting here all day. Let's give him a new trial date and then we'll go.
I didn't want Madam Clerk to think I
That's
forgot.
fine.
I wouldn't let you.
I know, that's why.
All right, we're gonna get trial dates on people.
April the 10th for trial.
This is all wrapped up. This is just the yeah, there you go.
Yeah.
Analyzing the car's black box is not going to change any of these other facts. I don't get it. You know, they're just putting it off. It's a
Did you tell him doing it?
Yeah, we don't.
it's a theory, I guess. I don't know the word I'm looking for. But you'd be amazed how many times these small towns lose evidence. So anyway, all right, cool. There we go. What's the guy's name again? I always forget. I always forget this guy's name. How did I shrink it? Judge David Wolf. That's his trial. Court. He's a good dude. And I have a plumber at the house. I think I need to go deal with that. I just heard that. Sage, take care. Guys, thanks for stopping by. Thanks, Fallstorm. We've got Waifu Cron's going to be on tonight. Wi-Fi Chrome. It'll be fun. It'll be a good time. So, yeah, let me go deal with what's happening here. Guys, please check out tonight. I can't remember what time I told her. 9:30, 8:30. What did I say? I said it earlier in the chat. Anyway. All right, guys. Let me go get the thing care of. Love y'all. Be good to each other. And I'll see you tonight. I think it's 9:00. I can never remember these things. So anyway, peace.